So, the idea of the video is to give you an understanding of where we are currently with the data protection laws in the UK and how they'll be updated come May the 25th, 2018 with the introduction into UK law of the GDPR. As I say, my take based on my experience of working within GDPR and other companies. Some caveats before we start. GDPR is not finalised yet. There is an outfit called Working Group 29 which produces various articles on an ongoing basis, and that group, Working Group 29, is trying to get to the bottom of the fine detail of some of the actual articles within the General Data Protection Regulations, or the GDPR. So Working Group 29 is still going to be producing bits and pieces as we go on, and probably will do so for another year or so. ICO, Information Commissioner's Office in the UK, will probably continue its really good work on GDPR. It's got some very, very good guidance pages for SMEs, big businesses, and anybody who handles data. And they'll probably keep going throughout this year and probably into the next. Website there on the screen. So, GDPR now within UK law is known as UK Data Protection Bill 2017, and it will by now, or by middle of next week, have had its third and final reading in the House of Lords and be returning to the House of Commons. Current data protection within UK, we're actually controlled by UK Data Protection Act 1998. For years and years and years, every single country within the EU had its own definition of a data protection law, and what was legal in some countries was not legal in others, and vice versa. So what we're trying to do now, 2016, all the EU member states agreed to the introduction of this new law to try and get some sort of commonality to cover the data of any EU citizen. Right, so GDPR, a whole load of scare stories running around the world. If anybody remembers the million bug of late 1990s, satellites were going to fall out of the skies, planes would turn left instead of right, washing machines would fail, supermarkets would shut, etc., etc. There was a whole lot of anti-feeling after the year 2000 when the dates actually rolled over into year 2000 with very little damage, if any. And it was either down to the fantastic work put in by a load of programmers and coders, or there never was a problem to start with. I like to think it was the former, and the guys and people worked really hard. So now, faced with a slightly similar problem, the world is suddenly full of qualified GDPR experts coming out of the woodwork, telling everybody what they need to do. There is no such thing as a qualified GDPR person. Lots of people have been on courses to get trained on GDPR. Data protection officers, very highly qualified solicitors in data protection are probably the best people to speak to. Whilst we're on this slide, just a couple of little notations there. ISO 27001 2013, if your company has achieved that security standard within the ISO group, you're very, very close to being GDPR compliant. There is a specific data security and GDPR compliance ISO standard coming on. It's not yet ready, but it's in the process. ISO 27007:2017. Plenty of stuff on the web about it. So, reality is, people are starting to panic now. You can understand why, with huge fines being thrown around the room, between 10 and 20 million euros, 2 to 4% of annual worldwide turnover, etc., etc. Self-shaming in the media. One of the main penalties for a data breach, i.e. when you get hacked, which is probably the most fundamental, frightening bit that most companies can face. So, GDPR is in reality just to try and reiterate into law what you should all have been doing for all this time, and you probably haven't with a great amount of effort. Some of you have been very good, some of you just a bit blasé really. So bear attention, some definitions now. I'm not going to read these out, but I'll leave them up on the screen for you. You can have a look. Data subjects, personal data, what a controller is, what a processor is, supervisory authority. In the UK, obviously, it's the Information Commissioner's Office. Recipients, enterprise, third parties, DPOs or data protection officers. So then, for years and years and years, you've been able to buy, sell, amend, steal, trade, dump data without any feelings at all, or any recourse really for people's privacy to do with their data. Nowadays, you're going to have to sit up and take care. Any information about an actual individual, sensitive information, email address, names, IP addresses, cookies, bank details, car number plates, passports, user IDs, anything like that, all now known as personally identifiable information, and you have to look after that. So as a data controller, a person who obtains data processor, somebody who actually does what it says, processes data, you've all got a duty of care to actually protect that data. And nowadays, users have a huge number of additional rights to ensure that the data is protected by you. And we'll go on to some of those in a while. Big new thing in GDPR is consent. Consent to hold somebody's data. If you mess up on consent, you'll be heading up into the €20 million fine bracket for a data breach. Consent, in the old days, quite often on websites you had tick boxes that were semi-greyed out with ticks in and all that sort of thing. Nowadays you can't do any of that. Consent must be freely given, specific to the task, informed and unambiguous, no longer open-ended blanket format or pre-tick boxes. So here effectively what you have to do is tell people exactly what you want their data for, how long you're going to have it, how they can actually amend their data and where they can actually appeal to. You must also have auditability and accountability on how you actually got that data. So your first big task for all this GDPR work as a business is check all your consent functions throughout the whole of your data capture processes. This will be websites, any form of marketing, any presentations, shows that you go to, and you can collect data. You cannot buy data. If you actually have data currently and you don't have consent for that data, you have to talk to each of those people within that data stream, either get their consent or remove it. You cannot have old data anymore without their consent. Privacy notices and information, big one here. You have to provide detailed information as to why you've got their data. It's got to be obvious. Can't have any double negatives, anything like that. People have to be able to understand exactly why you're wanting their data. Okay. You have to also add in here into your privacy notice the fact that people can appeal to the ICO or demand removal of the data from your systems. So right at the bottom there, big task for all your businesses, rewrite all of your privacy cookie notices, terms and conditions of trading, etc. on the web. SARS, subject access requests. Up until now, you've been able to charge people £10 a throw, I think it was, for telling them what data you had. Now the whole thing's spun around. A user has all sorts of different rights. You cannot charge the people for this, and you have to do everything within 30 days. And any SAR that comes in, you have to make a note of it. You have to note all your responses and actions to it. So there's a list here. People have a right to access the data you hold, data errors corrected, data erased completely, why you're processing the data, how long you keep it for, etc, etc, etc. Big task, create and stress test all the internal processes and procedures that will handle SARs. Okay, if somebody rings in, writes in, that's the start of a process. You have to be able to prove you've completed that SAR systematic subject access request properly, and it has to be totally auditable. Data breach. Okay, You get breached, or you get hacked, lose your data, you have to inform the ICO within 72 hours of that breach, or your discovery of that breach. They will tell you what to do next. The breach may be of no consequence. It might have been a load of encrypted data that was stolen, of which it's a secure breach, as it were. So there would be no steps for you to take. If, however, you've gone and lost somebody's very sensitive data to do with their medical history, children, anything like that, you're into self-shaming. You have to write to each of those people that had the data stolen. You have to tell them the likely impacts of what might or might not happen to them because the data has been lost or you're in neglect. So here at the bottom of the screen, big task, stress test, breaches policy, plan and test it.